Good afternoon, everyone, or morning, depending on whichever part of the world that you may be in. Um, as a convener and moderator of today's session, it is my pleasure to welcome you all to this important training. Now, given the numerous economic, legal, and technological development, the integration of information and communication technology, ICT, into dispute resolution processes has become indispensable. More so that the current global dispute resolution structures exposure to the COVID-19 pandemic has increased the reliance of technology by businesses and governments, and the pandemic has changed the world tremendously, as we all agree. And the use of technology in dispute resolution has become what we now refer to as the new normal. Although Africa is still experiencing some sort of challenges, and for those of us that are practicing in the continent will all agree to this, challenges relating to incorporation of ICT and artificial intelligence in the dispute resolution process in the continent. Although COVID-19 in a way has catalyzed the necessity of access to reliable technologies. So the primary purpose of online dispute resolution, as you will soon hear from our panelists and speakers, is to allow parties to resolve the disputes with the use of electronic technology, ICT, and these may occur in real time or in an asynchronous manner, depending on the rules of the ODR provider as well as the wishes of the party. So this process sometimes, or most times is, convenient, cost efficient than the in-person or face-to-face meetings, whether you're doing negotiation, mediation, or otherwise resolving existing dispute between business to business, business to consumers, consumers to consumers, or business to government. So the purpose of today's training, we've designed it to help small and medium enterprises and practitioners, to understand the characteristics and objectives of online dispute resolution, the advantages and the disadvantages of ODR, how to shift traditional ADR techniques, which we are all used to as practitioners, and handling disputes remotely, and how to navigate the different legal and technical issues arising from ODR. And we have lined up some of the finest practitioners in Africa to speak to us today, and I do hope that we'll find the session entirely rewarding. Now, starting with Professor Dr. Mohamed Abdel. I told him before the session, Prof's bio is staggering and remarkably long, so with his kind indulgence, I will just read out an abridged version. Professor Abdel is a chair of the Private International Law Department at Cairo University in Egypt. He's also the Dean of the Africa Arbitration Academy, Vice President, ICC International Court of Arbitration, Secretary of HICA Governing Board, founding partner and head of international arbitration, construction and energy at Zulfikar and Partners in Egypt, member of CIAP's Board of Trustees, member of the International Council on Online Dispute Resolutions Governing Board. I'm sure we are happy to have Prof today, given his relationship with ICODR. He's also the former Vice President of the IBA Arbitration Committee, former Chair of CIAP's Technology Subcommittee, and it goes on and on and on. Prof has served as arbitrator, counsel, and legal expert in more than 220 cases involving African, Asian, Canadian, European, Middle Eastern, and US parties. It features in IAP's Africa's 100 Leading Practitioners, was selected the African Personality by Africa Arbitration in June 2018 and by the SIAC in May 2019. He has received the Law Magazine 2017 Best Legal Practitioner Award, the 2018 ASA International Arbitration Advocacy Prize, the 2019 ICER Hall of Fame African Arbitrator Award, and the 2020 Client Choice International Award. Also, I learned that he has also won that award in 2021. Most recently, Professor Wahab was selected to feature among the top, there are 64 of them, world-leading arbitration practitioners as part of the Who is Who Global Legal Elite Thought Leaders in Arbitration, and he regularly features in leading directories. Now, Chambers described Prof, the 2021 Chambers, peers regard Mohamed Abdel as an absolute star in arbitration, who is Ruliger, the most recent one in 2021, says he's a top-tier thought leader and in a league of his own. Thank you very much, Prof, for agreeing to speak in this session today.
Thank you very much, Abayomi. You set the bar too high for me, but it's a pleasure to be with you today, and Itaya and Madeleine and all our colleagues. I'm very grateful. And I'm delighted to be speaking about a topic that is very close to my heart, a topic that we've been preaching for years, and everyone met that with a smile and saying, oh, that's not going to happen. So I'm delighted. Let me start by sharing with you the screen so that you have access to my presentation. Yes, I think you can all see it now. So let me start. My contribution today would be about two things, sort of disambiguating what we mean by ODR and trying to track the field by giving you a walk through the doors, the history, the present, and potentially the future, if I'm not mistaken on certain predictions that I would make. One key word to remember throughout my presentation, and I would venture to say throughout my colleagues as well presentations, and that's indeed important in our field, which is evolution. I think it's important to bear this in mind so that you're prepared to see what's coming your way in this respect. Let me start then by giving you an overview. Let's use an example to prepare you for this discussion. Telephone transformation, that's available online. It's not a slide that I personally put together, but it's interesting. So starting from Graham Bell, 1876, you see there tracking the development of telephones. And I know many of the younger generation would just look at this in museums, but I personally have seen some of these older versions of phones, in fact, at my home and my grandparents' homes in a way, until we reached, of course, the mobile, and then currently the present, whatever sort of we're talking about technology in terms of even now 5G, Android technology, everything in relation to handheld devices. And we think that's the pinnacle of the development and the evolution, and it's not. Because the new trend would be basically having like a sort of a very thin, fine bracelet instead of holding a phone, will be on your wrist. And even though R&D show that it's going to be a chip under the skin, you're not going to carry any device. These are part of the research on 3-5 components, where ultimately you're going to have really a phone just there under your skin, nothing more. And may even be evolving to something that we're not yet aware of yet. Anyway, so that's the situation. You see how things change over time. And I think this takes us to the point where we need to track what ODR was about. It's past, the present, and the future. So I thought of giving you a brief overview through history. Now, in the 60s up to the 90s, the internet was invented for academic and military purposes. At the time, it was banned from use for commercial purposes. So we have currently seen a shift from a ban on commercial purposes to a fully fledged online platforms of trading on the internet. So it was very interesting, a closed community of academics, military, and then we have the first internet service provider in 1992. Then the World Wide Web was invented. We had Netscape, which many of you may not be aware. And then we had an exponential growth. The latest statistics, as at April 2021, we have about 5.1 billion users connected, almost 53.4% in Asia, which is the largest continent, and about more than 92% of those who have access to the internet, so basically the 5.1 billion users, are connecting to the internet through mobile devices. So pretty much interesting to see the world we're living in and how the internet is in sort of progressing at an accelerated pace. Then comes, and I think that's a deserved tribute, in 1996, 27 years after the creation of the internet, the first article on ODR appeared in a law review. And Ethan Katz, whom we call the father of online dispute resolution, wrote an article about dispute resolution in cyberspace. Then they established the virtual magistrate, the online ombudsman office at the University of Massachusetts, and the family disputes ODR project at the University of Maryland. And Ethan published his first ever book on online dispute resolution, introducing the concept of what we call the fourth party, which is technology. In addition to the parties, the third party neutral, and now technology. That was online dispute resolution. And that was the first ever work on ODR. Then 2002 onwards, we see the establishment. You see there, I was a little bit young. We established the online dispute resolution UN Economic Commission for Europe expert group. That was a meeting in Geneva where we established basically the expert group meetings, and they started taking place annually to develop the field of ODR. And then we had a forum every year. Many people may not know, but we had the first ever ODR forum in Africa in 2004. It was hosted in Cairo. I organized it. I brought the concept to the Cairo Center, and we organized, and everyone with an interest in the field of ODR came to Egypt on African soil, and we had the first African ODR forum there in 2004. Colin Rule, of course, published the second book on online dispute resolution for business. You see there, business to business and business to consumers disputes from a practitioner perspective. At the time, he had online dispute resolution platform, and the idea was to track disputes in relation to eBay and other platforms and see how these high volume, low value disputes can be resolved effectively in a non-traditional way. Then in 2012, the third book, which is the ODR, considered the ODR treatise covering all continents and regions. It had ODR and theory, lessons on system design, artificial intelligence, mobiles and ODR, cross-border transactions, and ODR and government, and many others, ODR and culture, but also included a devoted part to tracking ODR in North America, Europe, Australia, Asia, Latin America, and Africa for the first time, writings on ODR. And that was the book that I co-edited with Ethan Katz and Daniel Rainey, and you can see it there. And by the way, this book is freely available online, in fact, now, and we're having a new edition coming out in 2021 on around September. So that is 10 years forward. We are revisiting this, and that will be the second edition. So there are three landmark books in the field of ODR. To just track a little bit this, so the takeaways from there is that between 1990s up until the 2000s, we had a rise in e-commerce dispute. The ban on commercial use of the internet has been lifted. Issues of spam, domain names, IP, things that were happening online did not immediately lend themselves to traditional dispute resolution processes. First of all, in terms of value, they were not high value. Secondly, they were quite fast-paced, so the traditional dispute resolution mechanisms in an offline world was not befitting. So ODR emerged as a possibility for resolving disputes online in cyberspace. At the time, I predicted that it would have a transition and a spillover to the offline world and will be used in offline disputes, but people were not very optimistic about this, and we see now this happening. Suppose this, there have been proliferation of online trading platforms. We see eBay, Alibaba, Amazon, and many others. With the advent of smartphones and ICTs, we now see even now high value and high volume types of disputes. And ODR had to tailor that, and then became a field that is capable of evolving and adapting to these disputes. But of course, the focus was on developing dispute systems and preventions as well as resolution. So you're trying to manage disputes, prevent them using online dispute resolution systems like feedback ratings, like trust mark seals, and many others. This has led us, and I say us because there was the group of ODR experts at the time, to write to the United Nations in 2010 to establish an ODR working group. As much as we have the arbitration working group, we have the transport working group, the UN has established working groups for many aspects of the legal field, and we thought that it's time to have an ODR dedicated working group. So 60 or 80 of us, we wrote that and we signed it, and the UNCITRAL established working group 3. Quite a coincidence, working group 3, when it was established, that was for ODR. Now working group 3 is very well known for the work they're doing in relation to investment arbitration, having concluded their work on ODR. Now, following that, there have been over the years, between 2010 and 2016, debates, discussions, meetings about how to develop ODR guidelines, rules, and what the expert group should be doing. And ultimately, as a compromise, they developed technical notes, and we will come to that in a moment. The interesting thing is that we now see a movement from the human third party to the automated fourth party, Ethan Katz referred to earlier, which is technology, and a great move from small data to big data, which we can have a separate presentation on big data and the cloud. But now cloud computing and computer processors that are able to process big data is a fact of life. It's not the future, it's the reality. Now, this brings me to the ODR technical notes so that you're aware and you're able to track the history there. The idea was to develop some rules in relation to cross-border low-value sales or service contracts concluded using e-communications. Now, to assist this, the Organization of American States had already e-commerce initiatives. There was the US on one side, Europe on the other side, and other parts of the world. The compromise situation was to develop these technical notes and to reflect the principles of due process, fairness, transparency, and accountability. They do not promote any practice of ODR as a best practice. They are not binding and are not suitable to be used as rules in terms of any ODR process to apply. But indeed, it has shifted the focus to a special field that is now spawning its own culture, which is ODR, and providing a framework for discussion and technical considerations for those engaged in the field. Now, over the past decade, even following the technical note, we've been fighting to promote ODR to the world. And of course, part of the comfort zone is that people are happy to continue to do what they're doing in the manner they're doing. And there was no incentive, motivation to use ODR schemes for traditional arbitration, let's say, or so. Even though ODR was successful with mediation, and we will hear from Madeleine on this, and we have also seen what I call the visible element of ODR, which is remote or virtual hearings, and we will be hearing from Isaiah on this. Now, the interesting thing is that in itself, this visible element of remote hearings, ODR per se, that's what we will see. And I would present to you and submit that it's not, it's one aspect, it's a tool, it's one element, but it's not ODR. But anyway, COVID-19 has accelerated this. This was back in 2010 in Vienna when I presented this, and I said, you know, at the end of the day, it's going to be a necessity very soon. And then COVID accelerated and showed us that the reality is that technology is unavoidable because of the situation that has unfolded. So again, necessity has become a reality, and this is where we stand today. Now, the framework, before we address this for ODR, we group them in three categories: the technological factors, the cultural, and the legal factors. You need all three, which is what I call the ODR triangle, to have a successful ODR process. Technology is indispensable. It's the fourth party. You need to have proper connectivity. And I know that's a little bit of a challenge for Africa, but we're picking up a lot of investments in ICT, infrastructure and connectivity, as well as matters of cybersecurity. So it is important and unavoidable to have this technological element. Cultural element is indeed important and challenging, because as people transition from a paper society to a paperless society and use technology, there's always trust and confidence issues. But what I can present to you as a fact is, as much as we have challenges and problems with security in hard copies and paper-based documents, it is no different in the online world. The whole idea is that for every sort of use of technology, you have a counter use or abuse in a way, and people have to be vigilant and in fact investing in the developing technologies to create trust and awareness and confidence in this regard. And of course, the legal factors are absolutely important, because without a proper regulatory or legislative framework that acknowledges e-business or e-communications, or give evidential value, or protect intellectual property, or deal with cybercrime, or provide an e-resolution framework for consumers or businesses transacting online, all the efforts would ultimately fail. Judiciaries, courts across the globe would need a legislative framework to work and navigate their way through these online applications. And so again, this is proliferating. So this is, I think, an important framework to keep in mind. And this brings us to the $1 billion question, which is, what is ODR? And I must say here, to take a stand objectively, saying even amongst the group of experts in ICODA, which is the International Council on Online Dispute Resolution, we have a disagreement on the definition of ODR, believe it or not. Almost 20 years later, we cannot agree a definition of ODR. So what you hear now is my own view of it, but not necessarily shared by others. And I will candidly share with you what others believe is the case. So is it a medium? Is it a tool? Is it a process? Do you use it for in-court, out-court? Is it simply using technology to resolve disputes, or what I have classified in one of my articles previously as technology facilitated, technology assisted, and technology based ODR schemes? What is it really? Does it encompass all this? And that's where the sort of disagreement, because many of our colleagues, and they have a very valid point, they say any element of technology used in dispute resolution makes the process ODR. To my own view, that means that we are actually having only ODR processes, because we communicate by emails through traditional arbitration proceedings, traditional mediation proceedings, and others. And this is an element of technology. We use video conferencing, and that's an element of technology. If that is going to be ODR, then this means that there is nothing called ADR, and that all processes we're doing is ODR. So that's the difficulty conceptually that I have with such view of ODR in that sense. And this, to me, what I present to you as a view is that my view of ODR is using state-of-the-art technologies, not just ICTs, but I think as well artificial intelligence, where you have technology is integrated, embedded into the process, so that at least it is wholly or substantially taking place online and resolved online. To me, that gives the fourth party, captured and coined by Ethan Catch, a meaningful impact. It's not just using it as a tool, but as a resolution mechanism. And that's what sets ODR apart in that sense. You may, of course, agree or disagree with that, but this is just an attempt from my side to make this transition or evolutionary step. Remember, the word evolution, I told you, is key. Evolutionary step from ADR to ODR. And ultimately, I will share with you this one of my concluding remarks. I would see that we are going to enter into the realm where ADR could ultimately disappear, and we will have ODR as technology takes over, whether for good or for worse. But the reality is that we see the trajectory that technology is taking over. Now, looking at the spectrum of tools of ODR, I'm not going to address each and every one because of time constraints, but I'm just giving you an idea. You have to understand that the spectrum of ODR is not fully aligned with ADR. So it's not that we have mediation offline, it is done online, arbitration offline, we have it online, negotiation offline, we do it online. ODR has spawned its own culture and set of processes that you do not encounter in an offline environment. And as I mentioned, I group these into three categories. The ODR facilitated online dispute prevention guarantees like trust mark seals, escrows, credit card chargebacks, feedback rating systems, and the ODR or technology assisted ODR schemes. And here we have an overlap with traditional ADR, which is basically arbitration, mediation, negotiation, online ombudsman, but increasingly so predictive justice applications, which are not encountered in the offline world, and e-courts and e-juries. And I think that's a distinctive element between ODR and ADR, because ADR, whether you take it as amicable or alternative, it does not encompass in-court processes. But ODR does encompass in-court processes, and we see that in reality. In fact, there are projects in China and beyond where we have using artificial intelligence and virtual judge to assist disputants with their cases. And this brings me to the final point there, the technology-based mechanisms where we have automated negotiations, advanced artificial intelligence solution set databases, ODR and blockchain, as we see smart contracts and blockchain taking over, and the AI judge that I mentioned, which by the way has been used to resolve over 400,000 cases in China during the last year only. And then the fear from everyone in our field, which is robots or robotic mediators and arbitrators taking over. And this is a controversial area in its own, whether we like it or not. But it's at least we see seeds of it to support processes taking place and a lot of R&D taking place there. I think the human element is important. The displacement of the human element, even though if taking place, I think ultimately we will come around, because despite the elevated level of efficiency that machines or robots or artificial intelligence can bring to processes, the human error element of things may be missed over the years and could be longed for in due course. In terms of parties, ODR is used and is suitable for business to business, business to consumers, consumer to consumer, which we see in the online marketplace, government to government, government to business, and government to consumers. And we see now as well, many government applications are offered online, including complaint systems, complaint handling. And this is one aspect on the spectrum of ODR. Moving forward quickly, ICODA, just to give you an idea, these are the members of the ICODA, those who establish the field and continue there as well. It's a non-profit consortium. Think of it as an equivalent of ICA, but in relation to online dispute resolution. The idea, that's not, by the way, an institution that settles disputes. It simply sets standards, open standards for ODR. That was created in 2017, following our annual forum which took place at the time in Paris, and of course promotes access, use, and public understanding and education of ODR, open to ODR practitioners, setting standards, mentoring professionals, and providing best practices for ODR programs. And it includes people from various interests and fields, not just arbitration, not just mediation, people even who are engineers and have nothing to do specifically with the law. We've developed a number of guidelines regarding the use of video arbitration guidelines or mediation guidelines. And of course, those of you will be familiar with the African Arbitration Academy on virtual arbitration hearings, which is an excellent protocol there. But ICODA provided some standards and principles there. Also payment best practices using ODR, as well as payment ODR standards. So these you can have a look online for on the iCoder website. This brings me to a little bit of my concluding remarks, and I believe I'm hoping to be on time with that. Artificial intelligence. We have moved a long way from ICT. Think of it as technology in its passive form, which is using communication, information technology as a medium of communication. And now we have artificial intelligence, which is cutting across all fields and sectors in business and in disputes. Maybe a little bit scary with where are we going to end up with artificial intelligence, but certainly a reality. And we see a lot of investments. And now, instead of just investing in AI in business to generate profits, revenues, people have now, post-COVID, shifted their interest to investing in AI in IA, which is international arbitration. And we see that with the predictive justice applications that are taking place. Now, we see now the use of artificial neural networks in a way. And now we see, as I mentioned, the artificial intelligence judge, the pilot project. Now, I know people are contrasting the human with the robot. My view of things is that with the development of artificial neural networks and investments in AI, it's not going to be humans versus robots in terms of use. It's going to be an artificially infused applications, so that we will see that possibly humans could be injected with chips that will help them. Think of it in a science fiction movie as the cyborgs, where they could have heightened abilities and skills in a way to process applications. I know this is a little bit scary and still medically under examination, but what I can tell you, the fact is, this is being tested to give humans heightened abilities. And we see that in normal medical applications where people who have lost their limbs are given artificial limbs, are given artificial organs to even be better performers compared to their natural sort of organs. Again, scary, but again, we see research and development in the area. Imagination is key, and nonlinear creativity is an aspect that we see in relation to the use of artificial intelligence and ODR. So no matter how hard we try to track the trajectory of the use of either information technology or artificial intelligence in dispute resolution, the limit is really our imagination and creativity. And Einstein himself, who's of course a well-known scientist, says that imagination is more important than knowledge. And this is, to an extent, how he reached a lot of the ways of science and predictions that he have done and the equations that he successfully developed. So anyway, I think the best way to predict the future is to invent it. We have to be careful how we invent it, as Alan Kay has mentioned. And this brings me to the few last slides, actually my last one before I leave you, which is ODR was traditionally perceived as the simple use of technology in the broadest sense. We are way beyond this. It's not just ADR online, it is integrated in court, out of court, and is, in fact, we see the fourth party technology taking over from the third party. Instead of assisting and supporting, it's taking over for dispute prevention, management, and resolution. AI applications will become normative in dispute avoidance, management, and resolution. And I now leave you with few predictions, one of which I mentioned and alluded to, which is chips being inserted in humans. I'm not sure I would want to live that age, but it's coming our way. We have to be careful that we use technology prudently and wisely. And this, who knows that? Believe it or not, I would not be surprised if many of you would not know it, but that is a handheld lie detector. Imagine witnesses entering arbitration hearings and now subjected to a lie detector test rather than an oath. what would that mean? And where would that leave us with witness testimony, for example? And what happens if we apply it to counsel? What happens if we apply it across the board to others? It's a very serious development. Whether people want to integrate that, I'm not advocating for it, but it's an interesting development. It's no longer the big machine in the room connected. It's a portable device that detects this. Holographic visual projections, assuming that humans will not be able to travel from one place to the other at the speed of light and time. Again, not sure that I want to live that era, but holographic visual projections. It's not going to be a two-dimensional thing in virtual or remote hearings. We are going to see holographic visual projections. That's not a prediction, that's a reality. Those who visit airports now would see holographic visual projections as information points of people giving them instructions and information. With that, I thank you. I went a little bit about 4 or 5 minutes over my time. I hope that's fine. But I think it leaves us with a lot to think about. But there you go. It's a field that is taking over the ADR field and exceedingly important. The final point I make is that with COVID, apparently everyone across the globe is presenting themselves as an ODR expert. So we will have to see how the situation unfolds, and I'm very much looking forward to the excellent presentations of Isaiah and Madeleine, and thank you very much for your time and for listening.